The commission would like to next call Dr. Michael Struett, Professor Struett.
Thank you. Thanks. I'd like to thank the Commission for the invitation to speak today. I'm a political science professor at North Carolina State University, and one of my areas of expertise is international criminal law and norms around human rights and accountability for human rights abuses. I should say that when I began on this career path 15, 20 years ago, I had little notion that I'd be applying those norms and standards to the conduct of the United States. But so for me, it's a little bit of a shock to be here today thinking about how should the United States go about accountability mechanisms. But I have looked at these through primarily a political science lens and thinking about what are the political dynamics that lead to successful accountability mechanisms. And so my purpose today is to suggest just a few things that I think lessons that we can take from the rest of the world's experience with trying to hold folks responsible for high-level atrocities committed by the state. I suppose another thing that I think this audience is now well aware of is that notwithstanding some very substantial efforts, as we've heard about from our last couple of speakers, at the local level, and of course efforts on the federal level as well, to this date, there has been no real systematic investigation and accounting for what happened with the CIA rendition and torture program. The Senate investigation is probably the most thorough, but of course we still don't have access to the complete results of that. And in many ways, it was unsatisfactory in its scope and how it went about. The Obama administration Justice Department opened an investigation and closed it on the grounds that the torture memos provided an excuse for what had occurred. But of course, as Juan Mendez said yesterday, that's going to appear, I think, to the international community and to the human rights community as an amnesty without real foundation in ethical and legal and moral principles. And so what can be done? Well, I think my greatest hope is that more could be accomplished at the state and local level. Representative Insco has told us just now about the efforts that have gone forward and how far those have gotten. But I still feel like this is a live channel of opportunity that should be pushed forward. There's a number of mechanisms that one could consider if you sort of look across the world at the variety of possible mechanisms. I think one promising idea in an ideal philosophical sense might be some sort of Truth and Reconciliation Commission. One could even go down the path of South Africa and consider offering amnesty or immunity to people who testify. I would suggest that those sorts of investigations and inquiries are usually most successful when there's some prospect of prosecution for people who don't fully cooperate with the investigation or reveal what they know. And one could imagine that on a North Carolina scale, primarily to deal with the aero contractors issue. Again, in an ideal political environment, maybe that would happen on a federal level, but that seems politically difficult for the time being. I also believe, as I've already suggested, that criminal investigations and trials probably need to be pursued. And the answers that we've gotten from the Attorney General's office, both when it was occupied by our current governor, Roy Cooper, and the current occupant, Josh Stein, about the reasons why they don't have jurisdiction or that FBI jurisdiction was preferable, I think are transparently not sufficient. Now, having said that, I'm sympathetic to their political position, right? In the history of the United States, we don't have a history of state and local government reviewing the conduct of the federal government with respect to national security questions, and that's understandable. So there's no bar association in the country where state and local attorneys and judges and investigators think it's their job to police the executive power of the federal government. That's perhaps unfortunate, right? That's maybe something that our culture lost. And I have in my written remarks, the quote from Alexander Hamilton, and Federalist 17, I think it was, when he was making the case for the United States Constitution, he actually argued that one of the reasons we didn't have to worry about having a sort of imperial presidency or an executive at the federal level that would be too strong is that the police power in the U.S. constitutional system is retained at the state level for the greatest part. And so, he thought it would be the states that would check any grossly criminal actions by the federal executive. And let's be clear, right? This point has been made this morning, but I think it's important to reemphasize. To the extent that folks have been detained without due process of law, tortured, never had an opportunity to come before a judge, those are threats to the constitutional fabric of the United States, right? Because if the government has the authority to do that to anyone, they have the authority to do that to everyone. And if they can do it in secret, we're all at risk, right? And so I guess what I'm suggesting is that I think there would need to be a sort of intellectual shift in how we see the relationship perhaps between state and federal authority on some of these issues. But there's a window here to do that. And in my view, there's no lack of grounds under the U.S. Constitution, under the North Carolina State Constitution, under federal law, under treaty law, which is part of the laws of the United States, to find the grounds to bring charges in state courts, certainly of conspiracy to commit kidnapping, if not other charges, right? Now, do the people most responsible for this program have such a tight connection to North Carolina jurisdiction? Probably not, right? But one could begin somewhere and push up the ladder of accountability. All right, so lessons from the past, right? We know that legal innovation is often an element of transitional justice mechanisms or accountability mechanisms when they're created, right? There's often a sense that the law doesn't allow you to hold those very powerful people who are abusing state authority to commit serious atrocities accountable. And there has to be a movement that begins, and usually that's an unpopular movement at first, right? Almost by definition, when states torture, they do so because of a perceived threat to their national security and their essential identity. And when elites or when the leaders of the state say, we need to torture, we need to detain people because there's a threat to our very way of life, right? Many people are going to believe them, right? So there's nothing particularly unique about the political situation that the United States finds itself in, where there's a lot of political support at the mass level for this sort of behavior, right? The other thing that we know, though, about public opinion about torture is that it's very sensitive to question wording. It's very sensitive to context, right? And my own view is that it only takes a relatively small but articulate and clear-speaking elite to persuade people that these fundamental human rights are more important to you than the threat of the next terrorist attack or whatever it might be, right? And so, that's what I think that this commission could potentially accomplish, and other similarly situated people who support the views, is to remind the American public that there's a reason that we say we're not going to put people in jail without due process of law, right? Not least of all because sometimes you get the wrong people if you don't ask a judge first whether or not there's evidence to hold the accused. Also, I think an important lesson from international experience is one about timing, right? Justice is obviously best when it's quick and swift and timely, but we know from the history of human rights battles that that's often not the case. Frequently, when people in power engage in human rights atrocities, right, they're not vulnerable to prosecution for some time after the fact. And I agree, I think, with Representative Insko that probably amongst the public in North Carolina, there's a sense that this was a political issue of the Bush administration or of the early Obama administration, and that we're done with that. But I think an important job for everyone interested in this issue is to remind people, first of all, that Guantanamo is still open and these detainees are still in custody, but also that no matter how much time goes by, if we're ever going to seriously believe again that there are legal restrictions on the ability of the federal executive branch to detain and torture people, we have to punish somebody for it, right? In the absence of such punishment, a reasonable person will always be able to conclude that, yeah, sure, we say that's illegal, but there's actually not really enforcement of those rules. And that's the challenge that I think remains to be faced going forward. In terms of Governor Cooper and Attorney General Stein, I've said I think that the fact that they didn't act in the sort of heated days of the headlines of 2005 and 6 and 7 is completely understandable. But it's also somewhat unexcusable, right? I think the point needs to be made to them that we don't want the federal government to be engaged in conspiracy to kidnap using North Carolina resources. But finally, I think there's a political opportunity for them, particularly in the age of Trump. We've seen that there's moral courage can be brought to bear on this issue. I thought Colonel Sterling's example this morning was exemplary of that, of people using whatever their professional role is to do the right thing on this issue. And I think an attorney general or a governor who became an articulate leader on this issue would find not just a North Carolina population that's behind them, but potentially a national audience for that message. And so I really do feel like there's a window of political opportunity here if we could persuade people to be a little braver and do something somewhat more risky perhaps than the way they envision their political careers going, but one that I think might even be beneficial for them. And then finally, I thought I should say something about the International Criminal Court, because that's an area of my expertise, but also because it's been mentioned. I've been saying for a long time that it's unlikely that the International Criminal Court would ever have jurisdiction over an American. Well, that's a less clear fact these days, right? The International Criminal Court does have jurisdiction over the territory of Afghanistan and some of the European states where black sites were held. And it's possible that U.S. conduct in those areas could come within the remit of the court, and that investigation is now live and ongoing. We don't know yet whether or not, formal charges will be brought against any individuals, and that's likely to be a long and lengthy process even if it unfolds, right? There's a number of political obstacles that would stand in the way of court taking action. But nevertheless, I think it's perhaps the existence of the International Criminal Court is perhaps an asset that local activists could use to make the case that we should have accountability mechanisms at the state and local and federal level, because the best defense against International Criminal Court investigation is complementarity. In other words, to show that you're able and willing to investigate atrocities when they occur using your own legal system. And if there's another lesson from international cases of accountability mechanisms, it's often an interaction between international pressure and grassroots activist pressure that reinforce each other, that leads to successful accountability mechanisms. So I'll conclude there, and I'm happy to take questions.
Thank you very much. Professor Struett, I'm going to initiate a question myself here. Both of these, I'm curious about this from a political science point of view. Both of these airports that were utilized by aero contractors are public facilities. They are governed by boards, whether it's a board of trustees or directors, or whether it's a county commission board. There's somebody who governs their activities and should exercise oversight. And so from a political science point of view, how could we best persuade such boards to take seriously their responsibility of oversight?
I think that's a good question. Of course, North Carolina has a long history of being supportive of the national security establishment of the United States as a host to Fort Bragg, most obviously, but in a long-standing way. The people of North Carolina support the U.S. military and its veterans deeply and profoundly. I think having people like Colonel Sterling in uniform delivering the message that we heard from him this morning might be the way to reframe this issue. In other words, I think the assumption was probably at the local level in Johnson County and other places that if you didn't let the CIA run its aircraft out of Johnson County, you were being un-American or against the defense of the United States somehow. And we need to alter that narrative and say no. Right? What it means to defend the United States is to uphold the rule of law.
Thank you very much. Other questions from commissioners? Commissioner Sparrow?
Thanks, Michael. I thought it might be interesting to elaborate a little bit more on what it might mean if there was any prosecution at the ICC level, and how perhaps this commission and the cases that have already been brought to light could inform the ICC as it looks at war crimes committed by the US government in Afghanistan.
Right. That's a very interesting and complex question. Of course, one of the mandates to the International Criminal Court is to deal with the international crimes that are of most serious concern. And usually that's thought to mean folks at the highest level of power and authority. An important limitation on the International Criminal Court's jurisdiction is it doesn't actually hold hearings or begin trial proceedings unless it has the accused in custody. Obviously, the prospect that the senior principals responsible for the RDI program would be in the custody of the International Criminal Court is fairly remote, to say the least, right? For those reasons, I think that even if that investigation advances, it would be a long process, right? So it would very much focus on, well, it would depend on the decisions of the ICC prosecutor about whom to name and how they targeted and structured their investigation.
And just thinking out loud that we have, for example, Gina Kodahi as Deputy Director of the CIA now, and she was actually directly responsible for committing torture in Afghanistan.
I would think that would be the kind of person that a prosecutor at the ICC might choose to focus on.
Yes, okay, thank you.
Other questions? All right, well, please join me in thanking Dr. Struett.